Good evening friends. Welcome to my YouTube channel Advocate Amit Kumar Gupta. In my series on the income tax cases, today I am going to discuss a very important case. The name of the case is RAJVEE Tractors Private Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 98 ITAT Tribunal at page number 459, and the matter has been decided by Ahmedabad ITAT, and this case is decided on 29th July 2022. The facts and the decision of the case is very interesting, and in fact it has a far-reaching effect on all those cases in which the additions are made on the basis of some material which come into the definition of the dumb documents. In this case, a survey was made on the assessee. During the survey, it was noticed that the assessee has not filed its return of income. Assessee admitted that he has earned a capital gain of 3 crore 13 lakh on the sale of a property for rupees 3.51 crore, and assessee declared the income of 3.13 crore in its return of income. The matter was over. Afterwards, the person to whom the assessee has sold the property, on that assessee also a survey was done by the department, and in that survey an agreement to sell was taken in that survey, and in that agreement to sell it was mentioned that the assessee who has sold the property has entered into an agreement to sell the property for rupees 5.47 crore, meaning thereby that the original assessee who has sold the property was showing the sale consideration of 3.51 crore, and the agreement which was discovered in the survey of the buyer was showing the sale consideration of 5.47. But this agreement was not signed by the seller. But the department, on the basis of this unsigned agreement to sell, reopened the case of the assessee under section 148, and an addition of near about 2 crore was made on the basis of this unsigned agreement to sell. The assessee went to the CIT appeal, and the CIT appeal also upheld the order of the assessing officer. So the assessee has to move to the Honorable ITAT. ITAT said that assessee has already declared the sale consideration, and the unsigned agreement to sell, which has been recovered from the survey of the purchaser, cannot be relied by the department without confronting it with the assessee, on which a notice under section 148 has been issued and addition of rupees 2 crore has been made, meaning thereby that the unsigned agreement to sell comes into the definition of the dumb document, and it cannot be treated as an evidence, because anyone can make any agreement to sell and can write any figure into that, but on the basis of that you cannot make the addition of any person. And before you are making addition, you have to confront the person on the basis of which you are going to make the addition, any person from whose the statement has been taken by the department. Until and unless that statement is confronted to the assessee, until and unless that document has been confronted to the assessee, you cannot make the addition. Apart from this, during the assessment proceedings, the assessee has asked the copy of the application which was made by the purchaser to the settlement commission for its case, and also the order of the settlement commission, but the assessee was not provided any documents on the basis of which a negative order was made on the assessee. So ITAT made a very welcome order giving relief to the assessee, saying thereby that the unsigned document does not have any evidentiary value and the addition should be deleted. And further, the ITAT said that any document which you are relying to make addition on the assessee, that documents should be provided to the assessee on his request, and you cannot deny those documents, because until and unless the assessee is in the possession of those documents, then he cannot make his case and he cannot even reply to the department. Friends, this is very important case in dealing with all those cases in which the additions are made under section 148 or 153C or 153A on the basis of the documents which are undated, unsigned, and does not have any evidentiary value. Friends, at the end of this video, I am once again repeating the name of the case. The name of the case is RAJVEE Tractors Private Limited versus Assistant Commissioner of Income Tax. Thank you, friends.